Small other things, but basically that is the role of the CJ.
Thank you very much, Honorable Judge. Please tell the Commission and the Kenyans who you are, Judge, in terms of you as a person, in terms of yourself as a judge, and also in terms of yourself as a leader. Those three parameters, please explain to the Commission whom you are.
Yes, thank you very much. My name is Martha Koome. I'm a judge in the Court of Appeal. I'm ending the criminal division at the moment. I have 33 years of experience, and a significant portion of those years have been served in public. I was admitted in the bar, having completed my degree in law in 1986, proceeded to the Kenya School of Law and graduated and was admitted in the bar. I subsequently did a master's degree in 2010. I have also done other professional courses to enhance my skill. I have practiced law for 15 years and before I became a judge. And my practice of law was in wide range of areas of law. I did not just practice law also to earn money. I was actively involved in public interest matters that solidified into constitutional review and law reform. I was a council member in the Law Society. The former Chief Justice, Dr. Willy Mutunga, was my chairperson, and we participated in the clamor for the review of the Constitution of Kenya 2010, participating all the way from Kamukonji, Ufungamano, and I was a delegate at the Bomas of Kenya. I'm proud to be associated with the 2010 Constitution. I was chairperson of FINDA, and in FINDA we spearheaded law reform that has led to a raft of reforms that now protect family. I was invited while at FINDA to join the expanded legal sector reform committee that was led by the Judiciary. Justice Omoro was our chairperson. We had all the stakeholders in the administration of justice. And we developed the blueprint that informed the reforms in the justice sector that was later on known as the GJ laws. In fact, while at the GJ laws, and in the family division, where I worked for 3 years, and I made reforms there, introduced a checklist and a bench book that helped the courts finalize the cases expeditiously. I was transferred to Nakuru, where I was the resident judge, and also initiated reforms there, case management strategy, court user committee. I also served at the Milimani Commercial Court. I served at the ELC, and I was appointed. I was later on transferred sometimes in 2009 to Kitale. Kitale was a troubled station then because there was a standoff between the advocates who were protesting against a judge, and there were no proceedings going on for a whole year. So when I went there, I was able, using my management skills, to quell the advocates, and we had a good working relationship. I was able to organize the work and worked in the mobile courts at Kakuma and Rokicha. I'm proud that the court we started as a mobile court in Kakuma now is a fully fledged court, a magistrate's court. So I was then transferred or promoted to the Court of Appeal. I've worked in Nyeri. Our bench in Nyeri is credited to have cleared the entire backlog and brought the station to real time. And that was a feat that has never been achieved anywhere in the Commonwealth. I worked in Mombasa, Marindi. Currently, I'm in the Court of Appeal here in Nairobi, ending the criminal division, where I've also initiated changes, was instrumental to the development of the practice directions, civil appeals that enabled the courts to manage the cases and reduce the backlog expeditiously, because it introduced a call over for the cases, so only the cases that are ready, that are fixed for hearing, and they proceed and we complete. Just now completed another practice directions on the criminal appeals, and also the Court of Appeal Registry Manual that I've worked with the stakeholders and the Court of Appeal staff. In a nutshell, that is what I am. But my background is that I'm born in rural Kenya, in Meru County, a village called Kevio. I think I need to bring that background. It is important because I grew up from an humble family. We were 18 children from 2 mothers. My father was a polygamist. I was number 8 from my mother. So my leadership as orientation started early as the 8th child of my mother struggling to, as a peasant, to put food on the table. I started mimicking her to see how I can help her reduce the burden on her. So I started working hard with my mother. I learned handwork from her. And because of her commitment, I was able to go to school. And thank God I was able to complete and to reach where I am because of the very good training that has grounded me well.
Okay. Thank you very much, Honorable Judge. Just a follow-up question. Please tell us whether you are a visionary leader, a transformative leader. I know you may have mentioned some of that, but just focus on, are you visionary, are you transformative?
Thank you, Chair. I believe I am both. I start by seeing the big picture of what it is that I want to do, the objective of the judiciary, and what we need to achieve. Is it clearing the backlog of cases? Is it ensuring that we have adequate resources to enable us do what it is that we have to do? So my leadership is situational, is consultative, is participatory, and throughout my life, the small nuggets I've given have been in leadership positions. From the Law Society Council member, I forgot to say I was also a member of the Council of the East Africa Law Society. In fact, it is my council that founded the East Africa Law Society when the community was also founded. So I was the inaugural treasurer and participated also in the community treaty document and in establishing the community bodies such as the East Africa Court of Justice. I've also served in the African Union as a commissioner between 2005 and 2010 when I was appointed by the heads of state, sitting at SIOT to represent Kenya as the commissioner at the African Committee on the Rights and Welfare of Children. So what I bring is regional expertise, leadership also in regional bodies, in local bodies. I was the chair of FINDA. I also have international experience, having worked with international bodies like the UNICEF, the UN. I am a certified human rights trainer by the International Institute for Justice, that is headquartered in Malta. I'm also a recognized human rights trainer by the Commonwealth Secretariat, having authored for them the bench book manual on gender-based violence that is used to train judges and magistrates in East Africa. So in this office of the judiciary, I am a transformative reader, because having participated in the transformation initiative by the Kenyans themselves to reform the constitution, to reform the law, to reform the justice institutions, and the work that I've done in the courts, in the family division as resident judge in Nakuru, resident judge in Kitare, starting the mobile courts, being the chairperson of the Kenya Magistrates and Judges Association, puts me in good stead, because I have good strategic partnerships from inside, from the magistrates whom I have interacted with as their president, and also with the stakeholders. I've just completed a very good exercise, very delicate and very important, on preparing a report on the state of children in the administration of justice. That is the NCAJ, the National Council on the Administration of Justice, Special Task Force on Children Matters, where we went around this country looking at the situation of children and making recommendations on what needed to be done, from the law reform, reviewing the Children Act, reviewing the practices, reviewing the procedures, and putting together all the policy documents that are needed to protect children. And for that, I was acknowledged by the UN, becoming the runner-up person of the year 2020. So I bring local, regional, international experience to the leadership of the Office of the Chief Justice. Thank you.
Thank you very much, Honorable Judge. Last question from me. What challenges have you faced as a lady leader, as a judge, in your career? And the second part of that question, Honorable Judge, is if you become the first woman Chief Justice in Kenya, what challenges do you expect to face, and how are you going to go about mitigating those challenges? Thank you.
Yes, I think that I believe the challenges that we face in the judiciary are completely gender neutral. They are the same challenges a male judge or a male judicial officer will face. But it will be historical for this commission to nominate a woman for the office of the Chief Justice, because it has never happened before. Leadership also is generally it's gender neutral. It doesn't require a man or a woman. None of the attributes of my being a woman or being a man would do anything in the office of the Chief Justice. It is the leadership skills. It is skills that will deal with the challenges that we face in the judiciary. Leadership, to me, simply put, is like driving a car. Whoever sits on the driver's seat, so long as you have the proficiency of driving, you have a driver's license, you know how to drive the car will go. That is the same as leadership. Whoever sits on the leadership seat, all you need are skills. In the office of the Chief Justice, you need people skills, interpersonal skills to deal with the people. You will deal with the judges, very senior jurists in the Supreme Court. You deal with the judges from the Court of Appeal, High Court, learned people in their own right. You deal with the bar. You will deal with the stakeholders. You deal with the executive. You deal with the registration and everybody. So you need skills. You need also managerial skills, because you will be oversighting, various things. No micromanaging, because you have the CRJ you have the departments, but you must understand, what is required of you. So as a lady, I appreciate everybody brings to the table something. So in the leadership, you are supposed to have, both men and women. So I'm very amiable to work with, so I can work with a cross-cutting range of people from diverse backgrounds, from diverse professions.
But you must have come across some challenges, maybe not necessarily as a lady judge, but generally in your career. I'm so interested to hear some of the challenges that you have faced,
yes,
how you have gone about them, and also what challenges you expect to face,
yes,
if you become the Chief Justice.
Yes, the particular challenges I faced them as a judge. I just discussed the challenges I faced when I went to Kitale. It was a court that was not operating for a whole year. So when they had a judge has come, so I had like 1,000 people appear in court one day. So what I did was to look at the portfolio of the cases that were there. I saw the prison was beaming, so I did revision of the sentences, and I was able to reduce the population of the prison by reducing the sentences. If you have been sentenced to serve 3 years and you have already served a year and there is a report that you are a person of good conduct, I would commute that sentence to the period served depending on the report, or commit you to community service so that you leave the prison, you serve from home. Then I looked at the other portfolios. Succession matters were so many because no grants were being used, and families who come to for succession matters, for the letters of administration are really hurting. They have lost a loved one, they are stranded. They need the grant so that they can move their lives forward. So what I did was to just sit there for 2 weeks and just completed like 1,000 grants that were clogging the system. And then employing the pre-bargaining in murder cases, because there were very many murder cases that were pending. Pre-bargaining is a system that is around in the law. When I read the files, I saw the ones which were really not murder per se, but were like manslaughters, but people have been charged with murder. So I was able to reduce the backlog of cases, and by the time I left after 1 year, the station was completely normal, up to date, working. In Nakuru, I also faced challenges because when you are the resident judge, you're in charge of a very large region. Those days, there was no high court in Naivasha. There was no high court in Nyahururu, Bomet, Kericho, Narok. All that area, we covered it as Nakuru. And we were only 3 judges. At one time, my other 2 colleagues were involved in tribunal hearings. So I would be alone in the station, all alone. So I would write letters to the Chief Justice asking that we get replacement magistrate, but as you know, because you have looked at the reports of the judiciary, we have always had a shortage of judicial officers. So the next time the advocates came, I told them, look, I don't hire magistrates. If I did hire, I would have hired actually 5, not even 1. So you go to Nairobi and seek an appointment from the office of the registrar to see the CJ. And that's what they did. They came, they saw the CJ. And that same week, by the end of the week, I had letters posting to magistrates in Nakuru. So there are many challenges on the backlog of cases. Is the major one because it affects Kenyans, and Kenyans want their cases to be heard expeditiously. Thank you.
Honorable Judge, we all have people that have helped us shape who you are as a professional, as a person. Who is your role model? Who is this person, or who are these people who have shaped you to be where you are today?
Thank you. I think I mentioned my mother. who had nothing, just tilling the land, but continuously playing for us, the girls, because we were 18, and we were, from my mother, we were 9, 5 girls, 4 boys. I was very close to my mother. So I learned handwork from her, prayerful. She was so prayerful. She would pray for us, kneel down until our knees really showed the marks for prayers. And she would wish that we went to school and that we were empowered so that we were not like her. So she is first and foremost my role model. Then my sister, who had beaten the odds in 1973, also graduated as a teacher. Graduation was celebrated in the village as the first one. And I told myself as a little girl then, I am going to graduate. How? I didn't know. But I kept my eyes focused on graduating. Later on, I've come to know other people like Professor Rea Marango, whom I've looked up because I also got married early. I was a young mother trying to balance a career, trying to balance my family. And I looked up at Professor Rea Marango, how she was also able to balance family life, career, and becoming the top, the first professor in East Africa. And also my friend, Dr. Jennifer Area. Those are women I looked up to. They were closer to me. But later on, I've seen other women judges from all over who have inspired me in a big way.
Thank you very much, Honorable Judge. And I'll now request Commissioner DCJ to ask you questions.
Thank you, my lady. You have been an insider for how long?
18 years, my lady, acting Chief Justice.
18 years, and most of the time you've been judge, you've been presiding judge. Resident is where we began.
Yeah.
Please tell us what you perceive to be, or what you do know to be, the administrative and judicial challenges in the judiciary right now that my lady will make a priority to fix.
Yes. Thank you very much, my lady, acting Chief Justice, for that question. The administrative challenges are many. I'll begin with the human resource register asset. When I was preparing for this interview and looking at the reports, especially the last State of the Judiciary report, it indicates that the human capital is at 46%. 56%. So we have a deficit of 44% of the kind of workforce that is required in terms of judicial, administrative officers, magistrates, and judges. We all know the shortages of judges that we have. We also have budgetary constraints because also looking at the reports, it shows that the judiciary receives 0.86. It doesn't receive a whole 1% of the national GDP. It's underfunded. The Judiciary Fund that is supposed to attract proper management and independence of the institution, secure the independence of the institution financially, has not been operationalized. So that is also a big administrative challenge. The other challenges are coordination of the core business of the judiciary, that is the work that judges do, to link it up with the support that we get from the staff, and to be able to consolidate everything and move seamlessly. Part of it, like in the Court of Appeal where I sit, is because of the infrastructure problems. It's also a challenge. IT, technology. Thanks be to COVID that we have been able to embrace some rudimentary technology to do our work. We have to struggle with that until we make it work. But that is also a challenge. I'm just talking of the challenges in the Court of Appeal because, like the chambers of the judges, the secretary sits like 100 meters away from the judge. The researcher also sits maybe 200 meters away, so the coordination of work so that we work smoothly is a challenge. Judicial, also one which cuts across is the shortage of judges, magistrates, and the shortage of infrastructure in some stations. There are some stations that do not have, judges. As we sit here, the Court of Appeal is not sitting in Nyeri or Mombasa. So those are challenges. And also, judiciously, the way we deal with the public and interface with the public, I think there is also a challenge communicating effectively, especially the judicial side with the public, for them to know how we designed our cases, what is judicial independence, so what is judicial interdependence. So we have a few things to iron out there. Thank you.
Please, my lady, give us your solutions.
Solutions. Beginning with the admin, I think the solution is to get the Judiciary Fund operationalized. I know the act or the bill to operationalize it is either in Parliament, in the floor of Parliament. So the solution here is to fast track it, and once it's operationalized, we can attract funding. The judiciary has always been supported by donors. We can get the government funding. The 17 billion that I heard was given to the judiciary. If it is put in the Judiciary Fund, and then we get other support from partners, it is put in the fund. Judiciary also collects revenue. I don't know whether it can also be put in the fund, but my view is that if it is put, then judiciary will never lack money to complete projects, because there are so many projects that are also stored, because even if we get the 17 billion, it is dispersed in tranches and in periodically. So sometimes it's delayed, and once you delay contractors, then you end up paying more. You end up losing value for money. So institutionalize, operationalize the Judiciary Fund, and then put in audits so that you get value for money. Because once you are able to account for what you receive and account perfectly and show the deliverables, you'll always attract money. Deliverables will always attract money. So have a system that monitors value for money. And then for the judicial challenges, we just have to get judges in the office. There are 41 judges who are pending appointment by the executive. we have to negotiate for them to take their positions. Like the Court of Appeal is running on almost less than half the regiment. So it's absolutely necessary that judges get appointed. When it comes to communication with the public, because really the public want to know why their cases are delayed, we must have a very good communication system. And I looked at the SJT, the Sustaining Judiciary Transformation strategy that I really recognize my lady, the Honorable Acting CJ, drove that process. It's a very good document. It has provision for SMSing so that Kenyans can SMS and find out where their case is. So, you know, there are things to complete the implementation in that strategy. I believe it's under review because it is 2017 to 2021. It's under review, and I think once it's reviewed, then we will be able to correct all the issues there that have not been implemented and begin another process of implementing the new strategy.
Thank you, my lady. Would my lady know the position? Being an insider, would my lady know where we are at with the Judiciary Fund?
That is the one I was not able to establish.
Okay.
I thought it's in Parliament.
We actually have the law itself.
It's up.
But let's go to the next point, which is this. The judiciary is a big institution present in the 47 counties. And we have that funding of 17 billion per annum. And my lady says that the fines we collect ought to remain with us. Would my lady tell us how that would be done, and go further and say what is the position on tax collection and that kind of revenue collection in the Republic, and whether or what my lady's position is on the economy, on the country's economy, and how that is to be dealt with.
Yes, thank you. I think the solution of whether we can use the revenue collected by the judiciary to put it in our fund is a decision that will involve the entire government because it touches on the whole framework, the whole configuration of how we collect taxes. But in my mind, thinking about how judiciary can be independent financially, I was looking at like the mortgage fund. We got a seed money to give loans to judiciary staff and judges to buy houses or build a house. Once we got that seed money, it was put in a fund, and then we borrow from there, and then we keep paying at a reasonable interest rate. That fund is almost up and going on its own because every month people are paying in. Then there are a cohort of applicants who are borrowing, and they are borrowing from that fund. It's actually sustaining. So this is a rudimentary way. I looked at, the Judiciary Fund. Once it's set, if our funds can also go there, then it can actually be sustainable. But that's a big negotiation. I understand.
Yes, and a big discussion, big discussion there.
Yeah.
On whether all the monies can be deposited to the fund at a go, and whether in fact that is possible. Let's go to another point. As my lady leads us in this institution, what does my lady know about the problems, if in fact they can be called that, regarding tribunals in the judiciary, how many are with us, how many are not, and what challenges we are facing there, and how my lady would help resolve them.
Very well. Thank you very much, my lady, Deputy Acting Chief Justice. There are very many tribunals. I don't think I can be able to say on top of my end how many they are. We have the Cooperative Tribunal, we have the Industrial Properties Tribunal.
My lady, the question
Standards
is,
Tribunal.
how many are transited and what challenges we are facing?
Indeed, all of them are supposed to transition to the judiciary, because I think we also have a judgment of the court that has stated that tribunal members and the staff are judiciary staff. So all of them are supposed to transition. So it is the usual business or push and pull, because you are talking of removing power of appointment, power of learning the tribunal from a ministry. So there'll be the usual teething problems, interministerial, that should actually be sorted through negotiations and understanding that tribunals belong to the judiciary. They are part and parcel of the judiciary. So if there are some that have not completely transitioned, is to fix a meeting with the line ministry and say henceforth the tribunal now is answerable to the registrar of the tribunals, who has been appointed by the JSC, is answerable to the CRJ, and is answerable to the CJ and to this commission.
Remaining on that tribunal problem, it's a big one in fact. The responsibility over the tribunals, is it the Chief Justices? Is it the JSC's problem? Whose problem is it? Who should be concerned about getting the tribunals transited? And by the way, what is the role played by the tribunals in the justice system?
Tribunals support the justice system. It's the alternative remedy that is provided for in most of the key areas of the economy. Tribunals are provided so that they are the first stop shop for somebody seeking a remedy. Say the tax tribunal. If you have a dispute with the KRA, then the first call will be the tribunal, because they are specialized and that is all that they do. The case will be determined expeditiously, and that is the principle behind all the tribunals. They are supposed to deal, the environmental tribunal is supposed to deal with environmental issues before now an appeal can be made according to the way it is provided for in the law, before they can go to the High Court, or if it is a tribunal set on disciplinary of a judge, before I think they can go to the Supreme Courts. So it is the first call where the problems are sieved, and it's a very important forum. So I'll look at a tribunal the way I'll look at a court, and say a magistrate is answerable to the registrar of their court, and then the case will go on to the chief registrar, and then it will go to the CJ. If it's a case in a court station where there is a resident judge, it will be the magistrate, the chief magistrate, and then the resident judge, and then it will come all the way, the channels that we use. Now, when we are talking about the tribunal, the chairman of the tribunal will be answerable, will be discussing whatever administrative issues he has with the registrar of the tribunals. And I believe every tribunal will have a deputy registrar as well. And then those problems will be escalated to and there are those which will be going to the Chief Justice.
The earlier part of the question,
yes,
is whose problem it is to sort out the problems or issues surrounding tribunals.
The buck stops at the Chief Justice's office, my lady.
Why? Why not JSC?
It depends on the kind of the problem.
Mm-hmm.
If it is a judicial problem on the decision-making issues, jurisdictions, issues, judicial, it is the Chief Justice. After all, my lady, the Chief Justice is also the chairperson of the JSC. So in his own wisdom, he will know what he can be able to deal with and what needs policy statement from the JSC.
Okay, I hear you, my lady. Let's go to something else, and it is this. Please listen to this statement. It is a fact that the majority of disputes in our society are not resolved through the courts. That is a statement of fact. Now the question is, how do you consider that statement of fact? Is it an indictment of our justice system? If yes, why? If no, why not?
The statement is factual, it's correct. And indeed, that is the way it should be. There is no way the judiciary can solve all the problems in the society. Problems are many. The judiciary is there to be as a matter of last resort. Problems that cannot be solved in the community, in the family, using these alternative dispute mechanisms, using mediation, those are very many problems. Problems solved at the chief's offices, problems solved at the churches, those are many, because I think everybody has a problem one time or another. And no one would expect all these problems to end in the judiciary. Judiciary cannot handle. So it's not an indictment of the judiciary. Judiciary is doing as much as it could and working hard to open multiple doors so that justice can be accessible, especially through the court annexed mediation, through the alternative justice system, empowering communities to be able to communicate with each other and deal with their own problems and solve them.
The next issue for our discussion, my lady, would be, again, a statement. I don't know whether you would agree with it. According to certain feminist legal theories, the law corresponds with or is part of structures of patriarchal dominance and oppression. I'll take that again. According to certain feminist legal theories, the law corresponds with or is a part of structures of patriarchal dominance and oppression. Does my lady subscribe to that position?
100%, my lady.
Now, please discuss. And as my lady is discussing, let me finalize my question.
Oh.
As my lady is discussing that, let my lady quote to us some prominent cases on the topic. And the last part of that question will come after we have heard the first part of the answer, my lady.
Okay. Thank you very much. The statement is correct that the legal structure is dominated by patriarchy. This is because our society is patriarchal. Laws are made in parliament, and the dominant majority in parliament is male. So it is informed by their background, by their statement, by their socialization, the way they are socialized. They are socialized to look at women as second-rate or second-class citizen, people who are supposed to be at home, homemakers, people who bear children, but are not supposed to take part in leadership positions. That's where we came from all the way from our colonial heritage. So we have come a long way, especially with the Constitution of 2010 that outlaws discrimination. My lady Chief Justice, you will remember even the Constitution of Kenya, the old one, outrightly discriminated against women. They could not confer citizenship. It allowed customary practices to prevail, to be recognized as part of the law. And we know customary practices were those which put down a woman, early child marriage, FGM were not outlawed. But we have come a long way now that the Constitution has even recognized affirmative action and enacted that in all appointed positions in public offices, you must be wary of gender equity in those. So there are many cases on declaring the rights or equal rights of women. The one that comes on top of my mind was a case of a woman, Sarah, I think she came from Namibia, and she went to a hotel unaccompanied by a man, and she was turned away. She sued the Hotel Intercontinental for discrimination, and indeed the courts declared that it was unlawful, it was illegal, it was discriminatory for the hotel to turn away a female guest simply because she was not accompanied by male. So we have so many other decisions on property rights. Women are entitled to matrimonial property which is acquired during marriage, despite the fact that the land was registered in the name of the man who was supposed to be the trustee of the family. We have many in succession law that say that women can inherit property, their status, their marital status, or their gender notwithstanding. So we've come a long way.
My lady, please distinguish, this is important, distinguish between the majority and the dissenting opinions in the matter of the principle of gender representation case in the Supreme Court on the same subject. That's part 2 of that question, and that will deal with the feminist theory.
Yes, thank you very much. The majority decision in the gender 2/3 case was that the provision is progressive. It's the 2/3 gender rule was to be attained progressively.
It was not a unanimous decision, my lady.
The majority decision?
We want to hear the distinct, what you make of the majority and of the dissent.
Yes, I was trying to lay the background
of
what was the majority.
Mm-hmm.
it was the rule will be achieved progressively, not instantaneous. The dissenting opinion was that Parliament is under obligation immediately to enact a legislation that operationalizes the section, I think it's 27.8 of the Constitution. So that was the difference, that one, it is immediate, the other one is progressive.
Which judges dissented?
The Chief Justice.
Alone?
Dr. Willy Mutunga, I think.
Mm-hmm. My lady, let's go to the various roles my lady will have to perform under as Chief Justice. And my lady enumerated those in the beginning. But let us start with the Supreme Court. In the Supreme Court, my lady will not be the Chief Justice. My lady will be the President of the Court. Kindly tell me the roles of the President of the Supreme Court and how my lady is prepared to fit in.
Yes.
And what has prepared my lady to fit into the roles of the President of the Supreme Court.
Thank you very much for that question, my lady. The Supreme Court has 7 justices. They are jurists, each one of them in their own rights. When it is a court, the Chief Justice is just a presiding judge in the court. He's one among the equals. His opinion just counts for one. So the role of the CJ, if he is sitting, because I believe he will not be sitting she will not be sitting all the time, because the quorum of the court is 5. So when it's 5 and the CJ is not there, the CJ will probably be the one preparing the course lists of the court and signing it out. Comprising or constituting the benches. The DCJ then constitutes the benches and prepares who presides. So if the CJ is not The courts, the deputy seats.
Maybe.
You have to approach them with humility. So it is important for you to be a team, to work together as a team. I think that is how I can reduce the meaning of collegiality is teamwork and working together towards the common goal. The common objective of the Supreme Court is to promote and protect the Constitution. So all of you to understand that important objective of the Supreme Court. So we are all answerable to Kenyans at the end of the day, but now the court alone must show Kenyans that we are here solidly behind the objective that has brought here, that Kenyans has brought us here to protect and promote constitutionalism, to clarify principles of law and build precedents.
All right, let's get practical here.
Yes.
You get onto the court, and 2 or 3 of your brothers and sisters develop a resistance towards your management style. How does my lady deal with that? We're talking about collegiality here.
Yes.
How does my lady deal with that problem?
I think this is a problem we face on constantly if you are in a position of leadership. I've been a presiding judge in many benches now because I'm a senior judge in the Court of Appeal. I kind of preside every day. And once everybody understands the objective for which we went to court for, we went to court to resolve a dispute. And therefore, when we hear the dispute and we return to discuss, people have divergent views. I, as a presiding judge, will have to now moderate, and we discuss and see where this one is coming from, where this...
What if, my lady, because I'm talking about collegiality here.
Yes,
I'm not
yes.
talking about judicial independence,
Yes.
which my lady cannot interfere with.
Yes.
Because each judge will rule as they feel they should.
Yes.
Although there's a role to be played there, but it isn't called collegiality. That one has another name.
Yes.
I'm talking about the very coexistence of the 7 of us.
Okay.
And my lady finds a problem of resistance. A problem of a difference in opinion in matters not judicial, not in the determination of the matter. My lady finds an issue with the way each one of us perceives things, in the way that my lady must lead, not just from the front, that's a tired phrase, but lead in such manner that to the greatest extent possible, the court is a team. So I'm looking for mechanisms of solving differences between just the 7 of us and getting us to move as a team. And the question has been, what has prepared my lady for that, and how would my lady resolve a situation like that? My lady must agree that if you are not working together to the greatest extent possible, that discomfort could translate into the efficiency of the court, right?
I agree. I agree because there are too few not to gel and work together. So if there is disharmony arising out of people's attitude towards my leadership, we will call a meeting, we will go on a retreat. And depending on the magnitude of the problem, we can even ask a facilitator to help us in the discussion, because always when people talk together, issues come out. What are the reasons that make my colleagues look down upon me and resist, like my lady you have put it, resists my management style? And what is the management style? Judges are completely independent in the way they make their decisions. Nobody can tell them decide like this and like this. So the disagreement is the work. Is it the work days? So we agree. We all know Supreme Court cannot sit every day. Even the Court of Appeal, we don't sit every day because we have to give room for writing judgment, very heavy duty judgment that require a lot of research.
All right.
Is it because the days are not agreeable? The cost list is not agreeable? Is it that they don't have secretaries? They don't have the work where or whither? So we find out the problems, discuss the problems, find the solutions, joint solutions, and from there we say let us join hands because of the objective that has brought us as Supreme Court judges. Let's own that objective, the mission and the vision of the Supreme Court.
All right, my lady.
And be accountable to Kenyans.
All right. These three are my last questions. The first is, and this is on the court now, what is the place of stare decisis on the mandate of the Supreme Court? The second one, what is my lady's position on a dissenting judgment? And the third question will be, my lady, is my lady aware of any, or are there in fact any amendments, recent ones, on the Act, the rules? And if my lady is aware of those, what would those be? And I wish you well, my lady. Just give us those short answers to the three questions.
Yes, indeed, they are very short because stare decisis, so the principle of precedent, is one that is founded in the Constitution. I think the article that creates the Supreme Court provides that the decisions
if my lady didn't read the Constitution now?
Okay. I just wanted to get that particular article.
No, just give us the import.
Yes, the stare decisis the principle of precedent, and it has been constitutionalized under our Constitution that judgments, decisions of the Supreme Court bind the other courts below. So the decision of the Supreme Court will be binding on all the other superior courts and even the subordinate court. That is the principle.
And on the court,
the court cannot be bowed forever because circumstances change, socioeconomics change, things are always shifting. So the court can always depart from its own judgment because this is the apex court. You can't stick to a position that has become redundant because the society has progressed and things have changed. So they have a leeway to depart from their own judgments. My position about dissenting judgments, these are very powerful tools in the development of the law. When a judge feels strongly that this is my view of the matter, and let me put my thoughts on the paper. Sometimes that dissenting judgment has actually become strong because of the circumstances. It is sometimes very futuristic, because the judge who writes a dissent is seeing to the future. And whereas these others, we always celebrate a dissenting judgment because it opens up the space, allows people to express themselves. Amendments on the rules and the Supreme Court Acts, I'm sorry, I have to look out to that at the Kenya Law Reports.
Thank you. No, we have the amendments here. We already have them gazetted and everything. They are available right here.
Okay.
I wish you well, my sister.
Thank you very much.
Thank you very much, Honorable Judge. I will now request Commissioner Judge Majaja. Oh, sorry, Commissioner Judge Wasame. Ask questions.
Thank you, Professor. Judge, let's start with Article 45.3. Parties to a marriage and the equality of rights. Does marriage per se give one of the opposite parties propriety rights, and why?
Parties to a marriage and equality of rights to the property. It depends. If I got married today, I have my property. My spouse will not be entitled to my property. The property I had before marriage, that's my property. So, and vice versa.
So the
if it
starting
is
point
a man and you got married to a lady, when he already has property, that is his property.
So
but when the lady comes into the marriage, let's say it's a house, and they develop it further, and put developments, they live in it for many years, she of course acquires, occupational rights. Yes.
So per se, marriage does not entitle one of the parties propriety rights. It's not a propriety relationship.
No, not in the instance. But once you live in it and you create other relationships and other rights within it, then those rights can be claimed. Okay. But once as you're entering, on the entry point, it doesn't.
Okay, my Lord, tell us 3 problems you will solve in the Supreme Court. 2 problems you will solve in the High Court within your next 30 days, if, God willing, you become the Chief Justice of the Republic of Kenya.
Thank you, my Lord Justice Wasame. That is at all wonder, because I haven't even known what problems are there in the Supreme Court for me to say I will solve them in 30 days. 30 days, I think, is a very short time for one to carry out an evaluation of the existing institution and, identify a problem and begin the process of solving. I know there is endemic problem of backlog of cases across board, to a little extent also in the Supreme Court. Maybe a low-hanging fruit is to say, let us do a service week in the Supreme Court to list the matters that are pending, the ones which are owned, and see whether we can reduce them maybe by 30% within 30 days. But like this is a Supreme Court which is established So one has to, first of all, meet the judges, meet the registrars, identify what is the problem, agree what is the mode of resolving these disputes. So that is the Supreme Court. Did you ask about the Court of Appeal, or you went straight to the High Court?
I went straight to the High Court.
The High Court also, one needs to meet with the leadership of the High Court, the principal judge, discuss what is the most urgent and immediate problem that can be addressed within 30 days. And the one that comes on top of my mind is how we can also have a service week in the area which is most urgent. The principal judge will be able to tell me whether it's a criminal that the criminal division is really and reduce them by a significant percentage.
Okay.
Yes.
One of the court, in my view, that has lost its identity.
Yes, that is a very important question, because the commercial court deals with businesses, deals with investors, and we need them to have confidence that when there's a dispute, it will be resolved expeditiously. So within the commercial court, we will look at multiple ways of resolving disputes other than through a hearing. There is mediation. And commercial transactions really begin with an agreement. People who entered into an agreement can always sit down and resolve the problem arising out of the agreement. So mediation, ADL, alternative dispute resolution, jump starting it, we'll see why things are going to clog the courts when they ought to go that way. And also embracing a case management system where parties file their documents, and then there is a call over before the case is fixed for hearing. Documents are agreed upon. So when you go for hearing, you don't even spend time on the witness box, other than if there is an issue to clarify. You just adopt the documents, you adopt the submissions, you leave the matter to the judge. The work is a lot also on the judge, but see how their capacity can be enhanced for them to work faster now that we have researchers. Develop some work tools and systems that assist the judge come up with a decision quickly. You have a template, what goes in the template, what the researcher information is supposed to bring. Those are things we will have to discuss with the principal judge, and the judge is working there to see how they can unclog the system, but mostly using the other multi-door approaches.
Okay, what about the manpower of that court? Because I know you worked there and I worked there during Gisheru's time. If you are not delivering, you could not be in that court even for 6 months. Is there, how will you deal with the manpower to ensure that court satisfies the intentions why it was created in particular?
Yes, I agree, my Lord, that there could be a shortage of judges there, just like there's a shortage of judges across board. But even looking back at when we worked there, we were not very many judges, but I think we were able to bring the backlog of cases to, I think the oldest case would have been like 3 years when we worked at Milimani. So which is still a long time because I read the judiciary transformation, the sustaining judiciary transformation strategy and the reports. The backlog should be a year. So, but this approach of case management, I don't know whether it's completely internalized and operationalized at the Milimani Commercial Court. So these are discussions to have with that court to see where is the cog, where is the hindrance. Why aren't we discussing this? Because every judge should also have their own docket. Like, for instance, when I went to Nakuru, there were so many cases. So we counted all the cases and divided them among the 3 judges. And subsequently, when a case was being filed, a new one, it was number 1, court number 1, number 2, court number 2, 3. 1, 2, 3. So all of us had equal number of cases. So if one judge is not performing, that will come out in the performance management, measurements, and also in your daily returns. So then you can do peer review on this one who is not performing. Say, look, you are bringing us backwards. Please pull up your socks. You ought to have finished 12 cases in a week. You are not finishing that. So, these are management, operational issues of how to effectively run a division.
Okay. The position I take is that currently the judges or the judicial staff are well resourced in terms of money, salary, and everything. Unlike during Gisheru's time, we have legal researchers in the High Court, Court of Appeal, and in the Supreme Court. We were very few then. We were around 42. And there's a lot of backlog. What is the problem, and how do you intend to solve?
Yes, this is a problem across board. When I served in Nakuru, when I served in Kitare, and also in the divisions, we were very few, but somehow we managed. Now we are so many, we are not managing. So that is an issue to interrogate. Is every judge having their own docket of cases? Or is cases all in the conveyor belt, going today, Judge A, B, C, D. Tomorrow they turn around, what was in number 3 comes to number 1. So it is standover generally, another tradition we found, which we worked against. So it is to examine those systems and see, because the one that works in my view and the one that I would be projecting and selling out is a case management system where somebody owns their docket from the beginning to the end, so that this file will not be before me today, tomorrow before you, my round, to the other day before another judge. These are always my file from the beginning to the end.
Okay, now let's discuss 3 areas. You said that you have not analyzed whether there are any problems in the Supreme Court, but I will tell you 3 instances, and you will tell me what you intend to do about it. The first one, my lady, is the case of Muriatetu. And the question before the Supreme Court was whether or not the mandatory death penalty is unconstitutional. But the court created, in my view, 3 problems which you need to solve. The first one can be found, and you see correctly also, to their credit, the advocates appearing for the petitioners, Mr. Ngati, a senior counsel, and Kilukumi, I thought also is a senior counsel, they raised only 2 issues in their submissions. But the judges captured what was the issue. And they said whether the mandatory nature of the death penalty under 204 of the Penal Code is an attempt forcing the trial court to hand down a sentence predetermined by the legislature, and whether that is against the principle of fair trial. Those were the two issues which they raised in their submissions. But the court created three problems, in my view, which you need to solve. You need to give us a solution. And the first one, they dealt with the issue of life sentence. And this is what they said, my lady. We acknowledge that Kenya and internationally sentence should not only be used for the purpose of retribution. It is also for the rehabilitation of the prisoner as well as for the protection of the citizens who may be harmed by some prisoners. We find the comparative jurisprudence with regard to interdeterminate sentence is compelling. We find a life sentence should not necessarily mean the natural life of the prisoner. That is one of the first issues which they have created. And they said it could mean a certain minimum or maximum time to be set by the relevant judicial officer along
you have a problem there. Just 1 minute, we solve the problem of the microphone for the judge. If this is working, maybe Judge Osaba, you could kindly come and ask from here. Sorry about that.
Sorry. Sorry, Judge. And as I was reading, Judge, they said it could also mean a certain minimum or maximum time to be set by the relevant judicial officer along established parameters of criminal responsibility, retribution, rehabilitation and recidivism. That is also the second problem which they have created, which was not part of the issues that was set for determination. In essence, they were saying in this judgment, life sentence does not mean life sentence. It can be interfered with by a judicial officer. And lastly, the third problem which I see is this. The Attorney General, the Director of Public Prosecution, and other relevant agencies shall prepare a detailed professional review in the context of this judgment and order made with a view to setting up a framework to deal with sentence rehearing cases similar to that of the prisoners herein. The Attorney General is hereby granted 12 months from the date of the judgment to give a progress report to this court on the same. And then again, they say, we direct that this judgment be placed before the speakers of the National Assembly and the Senate, the Attorney General, the Kenya Law Reform Commission, attended with a signal with utmost urgency for any necessary amendment, formulation, enactment of the statute law to give effect to this judgment on the mandatory nature of the death sentence and the parameters which ought to constitute the imprisonment. Those are three problems which is awaiting your resolution. How do you intend to solve them?
Yes, thank you, Myron. Thankfully, I've written an essay on the Muruatetu case, and it's part of my sample writing that I shared with the Honorable Commission, which shows that I'm acutely aware of, I would call operational problems that arose from that decision that affect the criminal justice system, and they need to be fixed. The judgment was profound. It was groundbreaking. In one pronouncement, that sentencing is judicial authority to determine the proportionate sentence is the discretion of the magistrate. However, death penalty is still a provision in our law, and it still remains. But death penalty as the only penalty is unconstitutional because it takes away the role of the judicial officer to determine the appropriate sentence to give. And the reasons are very well stated in that judgment, and we all agree with them that not all murders are the same. Some of them are grisly. Others are somewhere there. They are not manslaughter, but really you can see the violence that was met. Or the best example is robbery with violence. Not all robbery with violence are the same. Walking down here, some youth, 3 of them would like to grab my chain. They threatened me with a stone or something to beat me, and then they ran away with my chain. That's robbery with violence. And there are other robbery with violence where people come with guns, terrorize a family, rape, cause mayhem. That's also another robbery with violence. So when it comes to sentencing, before the magistrate would say, my hands are tied. This is a simple robbery, but it attracts death penalty because the ingredients of robbery with violence are present. The perpetrators were more than one. They were armed with a dangerous weapon. Never mind, it was something not really that can inflict. It's a knife, but they never even used it. But the victim felt threatened, and they robbed. So in that sense, it helped the justice, so that judges, magistrates can mete out proportionate judgments according to the circumstances of the case. Now, that judgment opened a Pandora's box by saying all those people who are sentenced to death apply for review, and also directed the Honorable Attorney General to come up with a policy and eventually the Speaker to amend the laws. This is our country. These are our problems. We have to solve them when they occur. So for me, immediately what I can do is follow up with the Attorney General to see whether that sector-wide report on sentencing has been prepared, to inform also our sentencing policy, so that our sentencing policy now takes into account the recommendations from the Supreme Court, so that, but having worked with the Muruateto in the Court of Appeal, we have also held this view, and I believe you are one of them, including my lady, the Acting Chief Justice, that this matter perhaps needed to be mentioned in the Supreme Court for certain clarifications. For instance, you mentioned a life sentence. What is life sentence? Is it 20 years? Is it 15 years? I think the Supreme Court would do well to define for us what do we perceive to be a life sentence. I think in the Court of Appeal, the trend is anything 20 years is a life sentence. But we need a coherent, coordinated approach to sentencing, and that is actually what is contained in my paper, which I prepared following a request from the President of the Court of Appeal. We had a whole week dealing with the matters where accused persons were sentenced to death, and they filed the appeals in the Court of Appeal, and then they have gone to the magistrate court where they were tried, and they have sent revision, and their sentences have been revised. When that sentence was already affirmed by the High Court and the Court of, and there is a pending appeal in the Court of Appeal. So we go to do appeals, they are called, and we were told they were released. You know, that looks like a backdoor release, because once the sentence was affirmed by the High Court, there is no way you can go back to the magistrate court. So there is a lot of instability in the criminal justice system. So when I'm Chief Justice, we can look at the Muruateto case again and core parties to mention and discuss those issues and see whether clarification can be given, because this is the apex court that should give directions to the other courts. And then the law reform, of course, should be involved, the AG and the public stakeholders, because this is a matter on criminal justice. And also we review our sentencing policy. Thank you.
So you will agree with the school of thought that says the Muruateto has created unpredictable, disruptive, and uncertain interference of courts against its sentences lawfully provided and lawfully imposed.
Thank you, my lord, but I don't think I would use that those strong terms, because I have already discussed how helpful it has been in helping the judges to determine a proportionate sentence to give. But there are other problems. It needed to be monitored. This is actually one judgment that needed to be brought for mention again before the Supreme Court within 3 months, so that the problems that were arising out of it, because this was a murder case. This was death penalty as provided for a murder offense. But through parity of reasoning, and you can't stop judges from exercising their minds to compare situations. It has been used for robbery with violence, it's been used for sexual offenses. Really, we are at a bad place in the criminal justice.
So, in your, just one of your sentences, you said, sentence a judicial authority and the judge or the magistrate should impose the appropriate sentence. In the circumstances of what the law provides in terms of minimum and maximum sentence, in all our statutes, both in the Sexual Offences Act, both in the Narcotic Act, both in the Anti-Corruption Act, the Mutudo Act, and many acts, they provide for maximum sentences, maximum and minimum sentence. What is your view? Does Murietetu apply to Sexual Offences Act?
My Lord, as you know, we sit within the Court of Appeal. We know it has been applied in sexual offences. And there are situations where I've agreed that it comes in handy to determine the proportionate sentence, especially where it's a case where there was no violence, there was consensual sex between the victim, and their age difference is not huge. Let's say the boy is 19, because we don't have a youth justice here in Kenya, and we need a youth justice. You cannot graduate from being a child at 18, and when you're just 19 and 20, you are dealt with strange hammer of the law. We need to nurture our youth. That is a failure of our system in the society. So in these cases where there was no violence, it's a Romeo and Juliet case. The age difference between the victim and the perpetrator is not huge. They were girlfriend, boyfriend. I've seen the Court of Appeal reduce the sentence to, say 5 years, or, depending on the circumstances of the case, a slap on the wrist on the perpetrator.
Okay. Now that we are discussing the Murietetu case, I just want to finalize. Do you think the problem is the High Court, Magistrates Court, and the Court of Appeal interpreting the judgment of the Supreme Court? Or is the problem the Supreme Court? Again, 3 years down the line, the Honorable Attorney General, the DPP, and both speakers have done nothing in terms of implementing the judgment. So where do you think is the problem?
Thank you, my Lord. I think the problem is all of us, the society, and we have to depart from, I think the Constitution requires us to stick to the values of consultation, participation, negotiations, reaching out. So we need to reach out, because I think the buck stops at us as the courts. It's the court that is being projected as the one which is not functioning, or which is not coherent in the way we are doing our things. So we need to take it up. And when I'm Chief Justice, I think the first thing I would do is issue a practice direction on how Murietetu should be applied. And I think, I believe my paper, which I've shared, has some policy recommendations.
Thank you, my lady. Mm-hmm. The second issue which I see a problem, which you need to solve, is the debate about substantive and procedural justice. One of the issues which you need to resolve is the issue that has confronted the Court of Appeal and also in the Supreme Court, about where to file the notice of appeal in election matters. And I have a particular case here, the case of Musa Sirma, where the notice of appeal was filed at Kaparnet, where the trial took place. But the judges took the view, the Court of Appeal judges took the view that this was not filed at the appropriate registry. The Supreme Court, addressing its mind, also agreed with us. What is your view on that debate?
Mm-hmm.
Because I know even us in the Court of Appeal were divided on that issue.
Yes, thank you very much. I think the Constitution gives us the command that we should always aim at doing substantive justice as opposed to looking into the procedure. But we all know that the procedure is the one that feeds the substance. And the procedure is the one that brings predictability, because I know if I have this kind of a problem, I will follow this procedure, and then eventually it will lead to substantive justice. And I belong to this school that asked, was the notice of appeal filed? Was it filed timeously? And I would overlook the fact that it was filed in Kabarnet Court as opposed to Nakuru or whichever the High Court that was hearing the petition. So like you say, this is undivided opinion, but since we are reviewing our positions before the next elections, these are matters which will be discussed by judges, and they come up with one common ground on the way to move forward in future, because perhaps it was not a mistake that they found in Cabernet. If that is where the case was heard originally, they probably overlooked the provisions of the law. We always say that ignorance of the law.
Comment on the merit of the case, but what you will do as a Chief Justice of the Republic of Kenya, the recent case of the BBI, where the Supreme Court, where the several cases were filed in the High Court and other cases were filed in the Supreme Court, I think by December or November, something like that, and the case was mentioned several times, but lastly there was a ruling delivered by the court on the 16th day of March 2021 saying, let the matters in the High Court be resolved. There is a school of thought that says, since the Supreme Court confirmed that this was a matter of great public importance, the High Court does not have jurisdiction, and it is only the Supreme Court that has jurisdiction, and that it was not right for them to refer the matter or to stay the matter pending the resolution of the High Court matters. What will you do? Because this is the apex court, and it must lead in terms of jurisprudence, and it must lead in terms of issues affecting the country. What will you do if you are the Chief Justice?
Thank you, my lord. Those are very turbulent, sensitive matters because they are live. I cannot really discuss them because they are sub judice. But since you have cautioned me not to go to the merits of the case, I'll just tell you what I can do. If these are matters of general public importance that affect a close section of Kenyans, I will read those files. We will call a conference of judges of the Supreme Court and discuss whether the Supreme Court takes over all the matters that are pending in all the courts and hears the matter. That will be, a discussion pending in all the courts and hears the matter. That will be, a discussion arrived at from a participatory and consultative forum of the judges of the Supreme Court.
Sorry, this is my final question, final question, I'm sorry. And I just forgot to ask a question that has been given to me by the Commission. How will you resolve the dilemma of the 41 judges? And this is a standard question for all candidates.
Thank you very much. This one must be resolved. like I said, through negotiations. There is one major problem I see with perception of what is judicial independence and what is interdependence. Because we are independent. The judiciary independence is secured in the Constitution. And nobody can claim to take it, and nobody should attempt to take it because it will be unconstitutional. But the judiciary is accountable. They go hand in hand. And the judiciary is interdependent because we all serve Kenyans. The executive serves Kenyans. The legislature serves Kenyans. Therefore, when the right hand doesn't know what the left hand is doing, or is not agreeing with what the left hand is doing, the body, which is now the Kenyans, are suffering because of the standoff. So when I was preparing for this interview, I know of the National Council on the Administration of Justice that brings all the actors together to discuss coordination of the administration of justice. I've also read the Intergovernmental Coordination Act that makes provisions on how the central government relates with the county governments. And there is a whole act of parliament complete with the mechanisms of how to deal with stalemates and standoffs. When I looked at the judiciary, we are interdependent as far as the delivery of service is concerned. And that's our core business, delivery of service to Kenyans. We get our money from the Consolidated Fund. We are part of the government. So we need to explain what is interdependence. Where do we come together on matters of administration of justice? The human resource, the capital, the budgets of the judiciary, the infrastructure, all those are projects that involve everybody. So we need an act of parliament operationalizing the NCAJ, and therein a mechanism for resolving any standoffs. Regular meetings with the executive, with the legislature, so that when the CJ is seen with His Excellency the President, people do not think that they are discussing a case, because our independence is in decision making and in hiring. The other things, we are interdependent. When the CJ is seen with the President, they are discussing matters on administration of justice, that everybody is responsible. It's not a beauty contest who serves Kenya better. Is it the executive, the judiciary? We are all in it. So if the judiciary is failing, the economy is failing because disputes are not being resolved. The president gets affected and everybody gets affected. So we must discuss this issue of 41 with the president in that atmosphere of we are serving Kenyans, all of us, and we are concerned about the administration of justice. And we find out where the problem is, resolve it, and get the judges in office.
Thank you very much, Judge, and I wish you well.
Thank you.
Thank you.
Thank you very much, Judge Koome. Honorable Commissioners, I would want us to take a 5 minutes break. I think we need to fix the lines so we are all together. So, Judge, you can take some water, a health break of 5 minutes. We come back 11:05. Thank you very much.
The search for the next Chief Justice. You know that it entered its second day with academician Professor Patricia Mbote finding herself in unfamiliar territory as she was confronted with questions over her integrity. Mbote, the first female professor in law, denied some of the allegations.